We will proceed to consideration of Resolution 112. Let me advise the House what we intend to do with respect to the debate on Resolution 112. It is the Chair's intention to take 3 speakers in favor and 3 speakers opposed to this resolution, in part because the opposition is for different reasons. Following those speakers, the Chair expects to entertain a motion to postpone indefinitely. All right? So for purposes of moving Resolution 112, the Chair recognizes Ronald Levin, delegate from the Administrative Law and Regulatory Practice section. Mr. Levin.
Madam Chair, I move adoption of Resolution 112 and ask for a second.
Second.
Members of the House, this resolution is co-sponsored by 6 sections: administrative law, civil rights, intellectual property, public utilities, real property, and science and technology. It's also been endorsed by the business law section, NCALG, and the Minority Caucus. I'm not aware of any ABA entity that opposes it on the merits. And I imagine many of you find the subject matter to be unfamiliar and perplexing, so to guide you through it, I'm going to first explain why we're proposing this, then how we created the proposal, and then what it provides. I urge your support for the resolution because it strikes a balance between the right to know the law and the interests of copyright holders. The resolution will enable citizens to find out without a charge what federal regulations require, and also will enable citizens to find out without a charge what proposed regulations would require, so that they can comment on those regulations to the agency that intends to adopt them. You may think that they have those rights now, and in most cases that would be true, but not when the regulation or proposed regulation incorporates by reference provisions in a code written by a private organization. Those groups are known as Standards Development Organizations, or SDOs. In those situations, the federal government does not publish the legal requirement, and so you can find out what it is only from the SDO and only on terms that the SDO decides. The SDO may, for example, require you to buy the standard at a price of $40 or $70 or hundreds of dollars or thousands of dollars. Some small businesses may be governed by dozens of these codes, so the total cost can really become unaffordable. Or consider an environmental group or a community group that is concerned about some local condition and wants to know whether a proposed regulation or existing regulation adequately protects public safety. It may not be able to afford to find out because the incorporated language is not in the public domain. This situation is antithetical to fair notice and due process. It's antithetical to the ability of citizens to hold government accountable, not to mention the ability of lawyers to do their jobs for their clients. Resolution 112 offers a carefully designed and balanced solution to these problems. It's balanced because of the open and inclusive manner in which ABA entities work together to produce it. Many of you will recall that 6 months ago I stood in the well of this House and announced that I would withdraw a prior resolution dealing with Incorporation by Reference, number 106A. Instead, I said a task force would be formed and input from everyone would be welcome. Well, the task force was formed with me as chair, and every interested section and division was invited to send representatives. We wound up with 15 members who brought a wide variety of perspectives to the table. We had a former chairman of the American National Standards Institute, ANSI, the umbrella group for SDOs. And we had the general counsel of a major SDO. And another member was the current general counsel of ANSI, who disagreed with the task force's ultimate recommendation, but certainly gave us her organization's viewpoint. We also had the executive director of the Authors Guild, who has some pretty strong opinions on copyright and kept us understanding copyright issues. And on the other hand, we also had several members who were strong supporters of broad public access to the law. This group worked intensively for more than 2 months to hammer out a compromise position. All members of the task force were encouraged to consult with interested members of their entities during this process, and I know consultations did occur. And we spent many hours on debate, editing, and mutual accommodation. Ultimately, this process resulted in the balanced and broad-based resolution that is now before you. So let's talk about the substance of the resolution. The task force began by completely abandoning the prior resolution 106A. Not a single provision in the old resolution remains in the new one. 106A had revolved around competing ideas about what incorporated material is reasonably available within the meaning of the Administrative Procedure Act. And it revolved around copyright issues that are currently in litigation. We knew we would never reach agreement on those issues, so we put them aside completely and replaced them with an entirely new legislative proposal. It has 5 key elements that I would like to highlight for you. First, when an agency issues a proposed or final regulation, it would be required to post the incorporated portion online, accessible without charge. This would apply to new regulations, not existing ones, which I'll discuss later. This online posting would itself solve the problem of people not being able to find out what those regulations or proposed rules require. Second, as I just mentioned, the access requirement would apply only to the incorporated portion of the standard, not the entire standard. For this reason, an SDO would still be able to sell copies of the standard to customers who want the whole thing, and this would help defray the expenses of creating the standard. Now, bear in mind that by one estimate, only 2 to 4% of private standards have provisions that are incorporated by reference into federal regulations in the first place. So obviously, businesses do have reasons to want to own voluntary industry standards for reasons that go beyond their incorporation in federal law, and those reasons would still help maintain the customer base for SDOs with respect to the ones that do have incorporation. Third, the required public access could be limited to a read-only format. Now, all of you know that when you work with a document, especially a highly technical one, you want to be able to mark it up, to highlight it, print it, or copy and paste portions of it into another document. Well, anyone who wants to be able to do any of those things with a standard would still have reasons to want to buy a copy, even if all or part of it is available online in a read-only format. So this fact, too, would help maintain a market for the SDO. Fourth, any material that is subject to copyright protection could be incorporated only if the agency obtains authorization from the SDO to allow public access. So that means that this plan involves no compulsory licensing, no stripping away of copyright protection. The SDO would still own the copyright. It could, for example, bring suit against third-party infringers to the same extent as it can today. Now, in practice, the SDO and the agency would have strong incentives to come to terms on an authorization agreement in order to maintain existing public-private partnerships, but it would be their choice. The resolution would leave it to the two parties to work out what the terms would be in any particular case. The agency and the SDO could agree on a payment from the government to the SDO. Now, there'd be nothing odd about that, really, because government spends money now to make its laws available to the public, from publishing the U.S. Code to maintaining websites to let people know what binding law is. But again, this payment would happen only if they mutually agree on it. And fifth, the mandates in the resolution would apply only to future regulations. If you have the text of it in front of you, that would be covered by the first resolve clause. With regard to existing resolutions, the third resolve clause requires Congress to urges Congress to require agencies to study those regulations and formulate plans for achieving public access on similar terms. But that's all it requires, to produce plans. What they would then do with the plans would be up to them. And hopefully some agencies would proceed to convert existing rules to online public access by conducting new rulemaking proceedings, if their resources permit. But 112 itself would not require the agencies to take any tangible action with respect to existing regulations. So the resolution is not non-retroactive. Now, if you put these 5 elements together, I think you can see why 6 sections joined forces to co-sponsor Resolution 112. Some members of the task force would individually have preferred more public access. Some would individually have preferred a better deal for SDOs. But they supported the compromise, and that's what we in the agency, in the ABA, do so often and to such good effect when we address challenging problems. Basically, 112 tries hard to hold down costs for SDOs, but it also makes an important contribution towards a fundamental goal to ensure that law should not be secret, and the ability to find out what it says or what is proposed should not depend on terms dictated by a private entity with a self-interest of its own. Rather, legal requirements should be accessible to all citizens, with or without deep pockets, as a democratic society should rightly expect. And for these reasons, I urge you to approve Resolution 112.
Thank you. The chair recognizes John Delli Venneri, an ABA member from New York, speaking with privileges of the floor.
Good morning. My name's John Delli Venneri. I'm the General Counsel of the American Society of Mechanical Engineers. Beverly Quail, one of the delegates, has asked me to come and speak to this resolution today. And she, just for full disclosure, is one of our attorneys. We're here because this resolution will create a cascade of unintended consequences that will result in a profound reduction in public safety. Indeed, this proposal will result in the destruction of an entire regulatory scheme that the federal government encourages and relies on. Now, this report, if you read it, seems to suggest that it only applies to things like consumer goods, like baby seats. But in fact, this resolution is so broad that it pulls into its sweep ASME's nuclear code that's used to manufacture nuclear facilities around the world, or our boiler and pressure vessel code that applies to pressure vessels the size of a house used in manufacturing. The point here, with respect to our codes, is that the vast majority of ASME standards that are incorporated by reference are used by people who can well afford the nominal cost of our standards. Now, our standards aren't simple legal edicts. Our standards are technical documents like equations for measuring the appropriate thickness of a wall in a high-pressure nuclear reactor. So what you have here, and this is a very, very, very important point, is a balance between public safety on one side and the hypothetical right of some unidentified person to have free, and I've heard the word convenient, access to standards that they have no duty to comply with. No duty to comply with. Importantly, what's striking to me is that there's no voice here of the regulators that rely on our standards, the nuclear facility operators, or me alone as the SDO community. The point here is one size doesn't fit all. Let me tell you a little bit about ASME. ASME is a 501c3 public charity. We have to use all of our revenue for the public good. We develop about 500 consensus standards. And we're referred to in the trade as a voluntary consensus standard developer. The federal government has encouraged the use of voluntary consensus standards, and it's a defined term, which I can't go into now. It's a little complicated. But the requirements of being a consensus standard requires that anyone can come to our standards committees and meaningfully participate. Big voices, small voices, big business, small business. All of our committee meetings are open to the public. Our standards are put on the web when they're modified for public comment, just as we do with the CFR. And most importantly, we do not charge a fee to participate in drafting our standards. Now, to remain this neutral convener, we must rely on the sale of our standards in order to support our public safety mission. Posting our standards for free on the web would essentially cripple our ability to develop our standards and do our public mission. So to give you some idea of the magnitude of the issue here, ASME relies on the contribution of approximately 5,000 subject matter experts to draft its codes. We've conducted a study that concluded that it was cost about $150 million a year to replicate our volunteer workforce. This is for ASME standards alone. What would it cost for all standards? The committee can't tell you. They haven't addressed that. The proponents of the resolution say, well, don't worry, we've drafted a compromise. Read-only access. Read-only access affords SDOs like ASME with zero real protection. Read-only access is an anachronistic notion that applied when computers weighed 50 pounds and sat only on desktops. In today's manufacturing environment, people read codes on tablets and smartphones, and internet access is ubiquitous. All you need to do is bookmark a web page. Ask the young lawyers section, and I was speaking about this to a group of young lawyers, and they kind of smiled, how much information they download and how much information they read on their smartphone. Another assertion is that the government is only going to post, hey, a small part of our standard that's actually incorporated by reference. Who says so? Does this task force have any empirical evidence to address what parts of our critical nuclear standards are incorporated by reference? The answer is no. Finally, the proponents have spoken about a compromise. Let me tell you how this compromise is going to work. It presents SDOs with a Hobson's choice.
Your time has expired.
Okay.
If you could wrap up.
Yeah, I said 3 more lines. SDOs must either surrender their intellectual property to the government at the price, terms, and condition it unilaterally sets, which may or may not meet the costs of doing the standard, or refuse to give up its intellectual property and thereby be prevented in performing its public safety mission.
Thank you, sir. I appreciate it. The chair recognizes Ellen Flannery from the District of Columbia on behalf of the Section of Science and Technology Law to speak in favor of Resolution 112.
Thank you, Madam Chair. Fellow delegates, I rise to urge you to vote in favor of Resolution 112. This resolution is simple. It is a balanced and measured approach to government transparency so that the public, small businesses, and lawyers can know what federal regulations require, while also importantly recognizing the copyright interests of groups that develop standards which are incorporated by reference into federal regulations. Resolution 112 calls on Congress to consider legislation that will provide read-only access to the parts of a standard that are incorporated by reference into a proposed or final regulation, so that the public can see what the requirements imposed by the regulation will be for purposes of participating in notice and comment rulemaking, and in order to comply with the requirements of the final regulation. The 6 co-sponsoring sections crafted a resolution that provides for government transparency while allowing standards development organizations the continuing ability to charge for downloading or printing of their standards. The SDOs argue that they should remain in full control to restrict access to the standards incorporated by reference. But this approach of SDO control is not working for the public. Let me explain why I am interested in this subject. I was a member of an Institute of Medicine committee studying accessibility and affordability of hearing aids. For this pro bono work, I wanted to see the performance standards applicable to hearing aids under U.S. Food and Drug Administration regulations. There were 16 ANSI standards applicable to air conduction hearing aids alone, which cost well over $2,500. There were additional standards incorporated by reference applicable to audiometers and other hearing-related devices. To access these ANSI standards for a public service project would cost multiple thousands of dollars. Judge Roderick Kennedy, a task force member from my section, likewise spoke about his inability to obtain standards that his court could not afford. On the other hand, I know the importance of protecting copyright interests, which are recognized in the U.S. Constitution and federal statutes. Our SciTech section's past chair, who is a former chair of ANSI, worked on the task force to address the SDO's copyright and commercial interests and ability to fund standards development projects. The SDOs have criticized this resolution on several grounds. First, they claim the public does not really need to know the content of standards that become regulatory law of the land. I disagree, and the co-sponsors disagree. Consumers, small businesses, lawyers, and others have the right to find the federal law embodied in standards that are now only referenced by name in the Code of Federal Regulations. Those standards affect a wide variety of products, including toys our children play with, hearing aids we need as we age, or boilers in our homes or businesses that could explode and cause damage or injury. SDOs claim that no one will purchase their standards if they are available in read-only format. We all know that access to the internet is not always reliable, and government websites are not always accessible. Businesses building nuclear power plants or buildings or boilers will want to download the technical standards onto computers or mobile devices or print them, and for that, they must pay the SDOs. Downloading would be necessary to assure easy and direct access to the content, technological agility in reading and using the standard, and authorization to print when needed. Third, SDOs claim that certain parts of standards need to be non-public for national security reasons, such as nuclear reactors. If so, there are other ways the government can address those security needs, and the SDOs shouldn't be putting them out for sale in any event. Congress can address this issue if they decide to take up our legislative proposal. Fourth, SDOs now claim this will have an economic impact of hundreds of millions of dollars. They provided no documentation of these claims during the task force discussions. They also appear to be presenting aggregate numbers for all the standards they develop. However, the Administrative Conference of the United States researcher says that only 2 to 4% of private standards are actually incorporated by reference based on government statistics from the Standards Incorporated by Reference database maintained by the National Institute of Standards. Fifth, if Congress takes up a bill on this resolution, all of these groups will be able to be heard. This resolution would give the ABA a seat at the table. In conclusion, I urge you to go forward and approve this resolution today. Thank you.
Thank you, Ms. Flannery. The chair recognizes Beverly Quail, State Delegate of Colorado. After Ms. Quail's remarks, we will suspend our debate with respect to Resolution 112 to take our special order at 10 o'clock.
Good morning. Resolution 112 should be opposed because the House should not support forum shopping or an end run around current litigation. The report doesn't tell you everything that's really going on here, and I'm not sure all of the sponsors and those who have filed salmon slips really know everything that's happened in this regard. In 2012, Professor Peter Strauss filed a petition concerning incorporation by reference with the National Archives. Professor Strauss is a past chair of the admin law section. This petition was joined in by approximately 18 law professors, including Professor Nina Mendelsohn. Professor Mendelsohn is on the task force representing the ad law section. Mr. Carl Malamud, president of Public Resource Org, who you'll hear from today, also joined in that petition. I'm going to call these people the legal scholars because that's what they call themselves in the pending litigation. Now, 2 subsequent petitions were also filed by the legal scholars before federal agencies dealing with this subject matter. And the small reference in the report to these federal proceedings doesn't tell you what the Fed decided, what the federal agencies decided. The OMB said the legal scholars' ideas do not serve the public interest. They want to make these standards free of charge. This means the cost of developing the standards are going to be shifted to others. That's us, the taxpayers. So who should pay? The taxpayers or the people that use the standards? Or if there's no shift to the taxpayers, then the SDOs aren't going to be developing the standards. This would have adverse, serious consequences on the ability of the U.S. regulators to protect the environment and the safety of the U.S. workers and consumers. So having 3 failed 3 times in front of the federal agencies, the legal scholars did something else. Public Resource Org took matters into their own hands and put 79 standards on their website that you could download anytime, anywhere for free. So then the SDOs filed a motion for a complaint for an injunction in the DC District Court trying to prevent this from happening. 4 members of the ABA filed amicus briefs in support of the position of the defendant, Public Resources. So the House should not permit an end run around this litigation. We should let the litigation proceed. And also, I'm not aware of a public outcry to get a hold of these standards. We heard about one anecdote from Ellen. I know lots of people, I know lots of clients. Nobody says, oh, I just want to read those boiler standards. And look at the footnote. They whine about having to pay $9,000 if you want to get a copy of the nuclear power plant plans. Now, who wants a copy of the nuclear power plant plans? Only if you want to build one. And so who should pay for those plans? Us, the general taxpayers, or the people that are going to build the nuclear power plant? Now, I'm a real estate lawyer, and I have a wonderful loan agreement. And you probably have great forms. Now, what if somebody said you had to put your forms and your work product on a government website, read only? Do you think that people would still come to you and pay to have you prepare a loan agreement or a deed of trust if your form is already read only on the government web page? Well, that's in a sense what they're asking these standards development organizations to do. I think that Resolution 112 puts free access to technical standards that most people don't want to read, they don't understand, over the public safety, and it should be voted down.
Thank you, Ms. Quail. Members of the House, we will now return to our debate with respect to Resolution 112. The chair recognizes Estelle Rogers of California from the section of Civil Rights and Social Justice to speak in favor of the resolution. Joe Potenza, instead, from the District of Columbia.
I'm Joe Potenza from the Intellectual Property Law Center section. I speak in favor. You know, I think we're hearing, and what I hear is criticism on both sides. But with the diverse task force we have and we enlisted, we arrived at a balanced approach. And I want to address a few points. The first one we heard was unintended consequences, and then we heard something about form shopping. Let's talk about unintended consequences. You know, Congress, the way this would be proposed, Congress would have the flexibility to accommodate any confidential material that might be addressed. Congress is not restricted to accommodate as well any varied interest and arrangements that could be made, and the agencies can make accommodations as well. Let's talk about this end-around litigation of form shopping. If you turn to the resolution, and you may not want to, but if you do, on line D, the legislation will provide that it will have no effect on any rights or defenses that any person may possess under the copyright law or any current law. Then we hear something about endorsing litigation, and the resolution in the report says, by adopting the resolution, the ABA would not itself endorse any views regarding the copyright status of any privately developed standards currently incorporated by federal agencies into regulations. The resolution would not imply a position regarding any pending litigation. And then we heard about the law professors went to the Office of Federal Regulation. And if you turn to page 6, adoption of the resolution does not signify any ABA views regarding OFR's interpretation of its authority under current law. It would, however, advocate a different approach under which greater level of access would be required. I mean, it's quite clear. These things were properly addressed. I mean, the problem that we have, and I think everyone in this room understands, you're attempting to read a book in portions. Let's say 4% are redacted. It's a problem. It's not easy when things are redacted. It's not efficient access. It's problematic if 4%, and it's problematic if you're dealing with complex standards. The balance that we arrived at to more and better facilitate access is what we're talking about. And to accommodate the varied interests that we were dealing with, we obtained and had the collection of many people, including STOs in 6 or 7 sections. Please understand that if there's copyrighted material involved and it's subject to copyright protection, the agency must obtain authorizations, and that could include payments as well. There's a variety of arrangements that could be made of copyright material. And agencies would not be able to incorporate copyrighted material unless it obtains the authorization. Congress has the flexibility to look at all of this and to look at particular agencies and to look at particular material. And that's all we're saying. We just want more freedom and more free access and resolve the kind of problem that Ellen Flannery was talking about when she was doing pro bono work. Thank you.
Thank you. The chair now recognizes Carl Malamud of California, speaking with privileges of the floor, to speak in opposition to Resolution 112.
Thank you for the privilege of the floor. My name is Carl Malamud. I've spent 25 years helping government put information on the internet. In 1994, I posted the U.S. Securities and Exchange Commission database and then donated my software to the SEC so that they could run it themselves. I've worked with Speaker Boehner's staff to post 14,000 hours of video from congressional hearings and with President Obama's transition team to help transform the Federal Register. For the last 8 years, I have been posting for free access technical public safety standards that are deliberately and explicitly made into law, such as 486 building, fire, and electrical codes incorporated into state law, such as 980 public safety specifications that have been incorporated by reference into the Code of Federal Regulations, the subject of Resolution 112 before you today. What is before you today is not a public access resolution, it is a private appropriations bill, one that fences off parts of the law as private property. Resolution 112, as written, encourages severe restrictions on the rights of citizens to read and speak crucial public safety regulations by specifying read-only access, a loaded term. Read-only access means you must pre-register with a private vendor before you can read the law. Read-only access means you must accept onerous terms of use, including a covenant not to copy any of the laws you wish to see. Read-only access means once you are permitted to enter the walled garden, you are presented with a website that prohibits printing, searching, copying, or bookmarking the law and discriminates against people who are visually impaired. These public safety codes have the full force of law. They are edicts of government. These regulations cover some of our most important public safety concerns, such as testing for lead in water, the transportation of hazardous materials on roads and railways, personal protective equipment for emergency personnel, the safety of toys, the safety of infant car seats. Promulgation of edicts of government is at the very heart of the rule of law. The rule of law means we are an empire of laws, not of men, that the law shall be committed to writing, that justice shall not be delivered on a whim. Writing down the law is meaningless if we cannot read it, but we must be permitted to do more than simply read the law. We must be able to freely speak the law, to share the law with our fellow citizens, to dispute it, to make it better. Edicts of government are the raw materials of our democracy, the bricks on which we construct our temple of justice. I hope this House will do more than simply reject the current language and instead reaffirm our commitment to making primary legal materials more readily available to the bar and to our citizens, and form a committee on promulgation to examine access to all edicts of government. 1 year after the American Bar Association's ringing celebration of Magna Carta, after a decade of global leadership with the Rule of Law Initiative, we must not now say citizens will get second-class access to read about public safety, that lawyers will need to ask permission before speaking the law. John Adams said that for our democracy to function properly, our citizenry must be informed. He said we must let every sluice of knowledge be opened and set a-flowing. But how can justice ever pour forth like a mighty stream if we do not let the law flow like water? How can we ever enter that city of equality if we lock our codes behind a cash register? How can we ever have access for all on the road to justice if we post a law high up on a cross of gold? Edicts of government are the property of the people, we the people. Edicts of government are how we define our rights and obligations in our democracy. The question before this distinguished House today is no less than, will you continue to stand with the people as you have for so many years? Today, I think we should all stand for the rule of law, and I hope you will reject or postpone this resolution. Thank you.
Thank you, Mr. Malamud. The chair now recognizes Beverly Quail, State Delegate of Colorado, for purposes of a motion. 5 minutes.
I move to postpone Resolution 112.
Second.
Thank you. I move to postpone Resolution 112 for 3 reasons. One, you've already heard. There's current litigation and motions for summary judgments are pending. I want the task force to come back after the motion for summary judgments have been decided and update their report. I want them to include the information in their report as to why the OMB turned them down. And in addition, have you noticed that there's no minority report, even though Mr. Levin said that the main SDO representative on the task force disagreed with the report and disagreed with what they were saying? Well, I called Patty Griffin, the ANSI representative on the task force, the person that really understands how these SDOs are used. And she doesn't belong to the House. She doesn't know anything about the House. She doesn't really know what a minority report is. But she said that Mr. Levin told her he didn't want to have a minority report filed, and he was troubled by her objections. And then he called her back three days later and said he was going to file a consensus report, and he didn't need anything from her. And so there is no minority report. But I have a June 2016 4-page report by ANSI to her institutions, her fellow SDOs, talking about why this compromise doesn't work for the SDO model, why it wrecks their model. That should have been included in the report. I think the report should be redone, and that minority report should be included. And lastly, there's nothing in this report about the costs. Everyone talks about free. Mr. Malamud wants free law like water. Well, you know what? Nothing's free. Everything has a cost. We heard Hillary Bass talk about how the Legal Services Corporation doesn't have enough money. So here we have a proposal that takes millions of dollars in development costs and wants the federal government to pay those costs instead of the people that use those standards, the manufacturers. That's money that we could use for better things like the Legal Services Corporation. So I urge the House to consider postponing this resolution. Thank you.
Thank you, Ms. Quail. The chair recognizes Susan Montgomery of Massachusetts from the Intellectual Law Property section to speak in opposition to the motion to postpone indefinitely.
Thank you. Hello, I'm Susan Barbieri Montgomery. I am a member of the Intellectual Property Law section, and I served on the task force, so I have some direct personal experience with the entire process since the mid-year meeting when the prior resolution was withdrawn and this was set up. I rise in opposition to this motion to postpone. I'm going to give you a couple of reasons, and if the light doesn't turn red, respond to some of the things that you just heard for the reason for the motion. 112 is ripe and ready for action by this House. It was developed by an exclusive and transparent process. As those of you who've been involved in the development of other resolutions before this House can fully appreciate, not only was there something that had come here from the ad law section, which a number of sections, including the intellectual property law section, had deep concerns about. Ad law withdrew it, stood before you, all of you, told you about the task force, and that all of you had the opportunity to have input. Then invited all sections. And all sections and divisions who were interested did participate in the development of this, and they appointed their own representatives to the task force, and none of them were turned away. What did we do? We spent a lot of time. I was there. We spent a lot of time. The first thing we did was we pushed aside the subject of the litigation. This resolution does not deal with the issues in that litigation. We also pushed aside. We saw the decisions that had been made by the OMB and the Office of the OFR, and we said, that's done. Let's look forward. Let's see if we can propose that Congress could do something to change the situation to address an issue. And that's what we did. And once that proposal had been developed, many drafts and drafts of comments, both the resolution and the report went to all these different sections representing very, very different interests and different groups of lawyers and different parts of our ABA. And each of those read the resolution and the report, separately evaluated, and voted to support it. And since then, another section, the business law section, has also given support to this. Those issues have even been further developed. I hope you read the report. You'll see that, in fact, we did include a lot of this information in the report. And since then, you've had many emails, things posted to the delegates, listserv, so you have even more information. 112 is ripe. It is ready for action by this House today. 112 is also an ABA resolution. It's not an act of Congress. It's not a decision of a court or the OMB. This is us, the ABA resolution. It's developed by the engagement and the integrity and the expertise of many, many members of the ABA, sections of the ABA with a variety of interests, and now you, the delegates representing, considering all of this. This is an appropriate and important issue for the ABA to speak to. The ABA can and should use its voice and its leadership to urge Congress to develop legislation that will protect and provide for citizens to have the ability to ascertain regulations, both when they're enforced and before, during the comment period. A right to know the law, if you will. As you can see, there are those who want you to vote against or postpone because they think we've gone too far and not far enough. Well, here we are. Is this right a, quote, hypothetical right? I don't think so. I don't think it's only the people who have a duty to comply that have a right to see a complete regulation. And those of us who advise others know that as well. There's government boards, local and state. There's public organizations of oversight. There's citizens who want to know. There's lots of people who have a real right, not a hypothetical right, to see the complete regulation. Should we wait for the motion to dismiss? No. We could report that there was a ruling. We could add that to the footnote. But this resolution does not address the issues in that litigation. Did we do something inappropriate about the minority report? Ron's now not going to have a chance, so I'm going to speak for him. I know what he did.
Ms. Montgomery, your time has expired.
Sorry, okay. He did speak to Rules and Calendar and take their advice on whether a minority report was required. I ask you to vote against postponement, and then I ask you to continue to deliberate and to vote for Resolution 112.
Thank you, Ms. Montgomery. Could you activate, please, the floor mic? For what purpose does the delegate rise?
Good morning, Madam Chair. Robert Weeks from the Santa Clara County Bar Association. I rise to a point of parliamentary inquiry. I understood the chair to say earlier, after speakers on each side of a certain number, she was going to entertain a motion to postpone indefinitely. However, I heard Ms. Quail make a motion to postpone, which is different, and did not hear her say to a specific time or date for that. So I am inquiring as to what the motion actually is.
Ms. Quayle's motion was a motion to postpone indefinitely.
Thank you.
Does that satisfy your inquiry?
Thank you, Madam Chair. Yes.
The chair advises the House I'm holding a number of salmon slips, both in favor and in opposition to the motion to postpone indefinitely. The chair hears that there is a motion to call the question. That is not a debate. So all those in favor of calling the question, that is the motion to postpone indefinitely, please say aye. Aye. All opposed, no. The ayes have it. We will proceed to a vote on the motion to postpone indefinitely consideration of Resolution 112. All in favor of the motion to postpone indefinitely, please say aye. Aye. All opposed, no. No. The chair is in doubt. This is why we have tellers. All in favor of the motion to postpone indefinitely, please rise and remain standing. Thank you. You may be seated. All those opposed to the motion to postpone indefinitely, please stand and remain standing. If you are here with privileges of the floor, please do not stand or attempt to be counted. The motion to postpone indefinitely fails. We will return to debate on...
Second.
The chair is not in doubt that the question, the motion has been made for the question to be called. All those in favor of calling the previous question, that is the vote on Resolution 112, please say aye. Aye. All opposed, no. The question is called. We'll proceed to a vote on Resolution 112, and you are correct. There is a right to close. The chair recognizes Scott Partridge for purposes of closing with respect to Resolution 112.
I too have a flight this afternoon, and I appreciate the time that the House has devoted to this very important issue. And I would just point out one thing as we proceed to a vote, and that is that there's a certain irony in what we have seen in the debate that we've heard this morning. And for me, this is unique. In 17 years in the House, I don't think I've seen anything quite like this. The opponents include someone from Public Resource who says everything should be disclosed, and the opponents include someone from the SDOs that says nothing should be changed and our rights should be fully protected. And interestingly enough, what does the ABA do? Well, it does what good lawyers do in any kind of a transaction. It looks for an appropriate compromise, something that settles an issue and advances the ball. If you pass this resolution, we will have a seat at the table with Congress as to who is right. If you defeat it, the parties that you heard from this morning, the SDOs and Public Resource, will be very happy because they'll both be at the table, but we will not. I urge you to vote for this resolution so that we are at the table to come to an appropriate compromise to assist Congress in resolving this very important issue. Thank you very much.
Thank you, Mr. Partridge. There was a request for the vote count with respect to the motion to postpone indefinitely. There were 141 votes in favor and 206 votes against. We will proceed to a vote on Resolution 112. All in favor of adopting Resolution 112, say aye. Aye. All opposed, no? No. The ayes have it. The resolution is passed.